let us acknowledge the Indigenous people of all the lands that we are on today. From coast to coast to coast, we acknowledge the ancestral and unceded territory of all the Inuit, the Métis, and the First Nation people that call this land home. And we've got two presenters today, Trudy Raymond, who you maybe have known before. She comes by quite frequently to help us with our wealth management. And she is, of
Sorry,
course,
Jen, I'm
yeah.
actually not presenting today.
Are you? Oh, I thought you were.
No, I'm actually supporting Leon here. Just
Okay, I thought you were. I thought you were talking to.
all
Okay,
good, all good.
okay, never
Me
mind.
out.
Trudy is here anyway. If you need a question, she can help you. Okay, but Leon is our main uh, guest today, and he is from the Thomas Efraim Law Firm. All the information for Leon is in the daily emails that you've been getting, and I'll also put it in the chat if you want to talk to him more, if you have more extensive questions that he hasn't figured or isn't able to answer today. Of course, he'd be happy to talk to you. Okay, without further ado, hello, Leon. And I'm just going,
Morning, everybody.
here we go.
I mean, good afternoon, everybody.
There you
I,
go. Hi.
I can see that there's about 150 of you on this conference, so that's my biggest crowd yet, I think. So I'm pleased to be with you all. And so let me just explain that I provided Jen with a presentation, a slideshow presentation that I generally give on wills and estates. That's sort of a 30,000 foot level overview of what various terms mean in the wills and estates context, and how to prepare your wills, and what the various roles that people play and the various options. And so I've given her that to share with everybody because I believe you were all given an opportunity to provide some questions that I could use as talking points for today's meeting. And so what I've done is I've created another slideshow to make it easy to follow along with the questions. And what will come out of my responses to several of these questions will be a lot of the general points about wills and estates that you'll want to know. Some questions only came in today, so at the end, I'll bring them up after I've gone through the slideshow. So as much as I'm sure you're all enjoying looking at me, I'm going to share my screen for this presentation. If you'll just give me 1 second. Go. Okay. Okay, so let me share that now. I think I have to close this. Share screen. There we go. Okay, so can everyone see this slideshow now? This is the first square, art your service, wills and estates questions. So
Yeah,
next.
you might want to put it on the slideshow so we don't see the side ones, so you just see the big one.
Oh, I'm
So,
not sure how to do that.
so if you go up to the top menu there, beside animations, you'll see a slideshow. At the top, so it says File, Home, Insert, Design, Transitions, Animation, Slideshow. Right at the top, where the file is.
Oh yeah, okay, I have to move this then. Oh yeah, slideshow.
So you go slideshow and say current slide from beginning or from current slide.
From current slide. Oh, look at that.
Yeah,
Thank you.
no worries.
So now here's just some information about us, our firm, what we do. Some of you have already written to me independently. That's fine. It's interesting. Some of your questions are a little more complex than just that they warrant a little bit more than an email response. So you'll note we do a half-hour free consultation. Nothing usually takes more than a half hour. And so you just feel free to write to me or call my office and ask to speak to me, and we'll take care of whatever your questions might be. And by the way, the fellow beside me, that's Dave Thomas, the founder of this law firm. He retired just this January, but he still consults with us, and he'd been practicing in Oshawa since 1976. So, question 1. We wanted to update our wills and wanted to ask whom we should speak with to get this done. Can we do this on our own, as ours is very basic? Does it need to be reviewed by a lawyer? I start with this one because it's a pretty easy one. Now, as a lawyer, I'm going to say that you should always engage a lawyer when you're dealing with legal documents. That being said, there are a number of online services that provide wills and estate planning services as well. However, again, those services are very clear that they're not offering legal advice, that you're taking all the risks that are all the potential risks that could arise from doing your wills that way. In terms of amending a will, if you have an existing will that you just want to make some changes. So for example, one of the most common ones, and I think this would likely affect many of the people on this video conference, the last time you did your will, your children were minors. So at the time you named guardians and you named close friends or siblings as your trustees. But now your kids are in their 30s or even in their 40s, and you have grandchildren, and it just makes more sense for them to be your trustees. While that isn't a complicated update, you are in effect creating all new wills because you're changing your trustees and you're modifying your beneficiaries and how your beneficiaries will receive their inheritance. So for example, at my firm, if you've already done your wills with us before and you just want to update them, sort of the scenario that I just explained to you, the total cost is $295 plus HST. If you already have wills that just need updating and you can provide us with those copies, again, the cost is just sort of $295 as long as whatever changes you're making aren't too complex. So I guess if you're going to do it on your own, there are two things you should make sure of. And one is that you're getting it witnessed properly, and that you're not creating any confusion in the will. So again, these are the reasons why I suggest that people deal with or work with a lawyer, even if it is an update in a very simple scenario. Question 2. I combined these two. Oh, no, this is one question. If I make a new will in Ontario, will it be accurate and acceptable in BC? And then, for example, I have 2 grandchildren. I want to leave money in trust for them, and I want to set up the disbursement in my will. Will this hold regardless of which province I am living in when I die? Unfortunately, the answer to this is no. If you are resident in BC and your assets are in BC, then unfortunately you will have to have a BC will. So if you used to live in Ontario and you have an Ontario will and you move to BC, the best thing you can do is get a new will done in BC with a BC lawyer. The question about leaving money for your grandchildren in trust is sort of a different question from the question about jurisdictions. So while the idea of the jurisdictions still holds true, I think it's important to understand that your will in and of itself, when you pass away and the will takes effect, you've already created what's considered a trust in the eyes of the government. So basically, you're leaving all your assets to your estate trustee in trust for all the beneficiaries. So as soon as your will becomes effective, you've created a trust. Now, you can create separate trusts for your beneficiaries within the will. And we're going to be talking about trusts a little bit later because trusts have become a much more complicated area over the last 5 years or 10 years and have become even further complicated this year due to some new CRA rules that I'm going to let you all know about. But then, so for the person who asked this question, if you have moved to BC and you have an Ontario will, you probably need to get a BC will done. And if you want to leave money for trust in your children, you're absolutely able to do that in either your BC or your Ontario will. And then the terms of the trust are up to you to decide, and we'll discuss some of those things shortly.
Hey,
Question
Leon.
3.
Yeah, and before you go into this next question, somebody just sent in a question to me, and I think it's around this, it's the same thing.
Okay.
Judy wants to know, she made a very simple will when she was living in England many, many years ago. Is that one valid in Canada? And if I made a new will here, would it be valid in England?
No.
Okay.
So, and there's also some serious tax implications about trying to have, say, your Canadian will govern your English will. So the tax regimes are different, estate taxes are different, and as I understand it, you're probably better off letting your Canadian assets be dealt with with a Canadian will, and if you still have any assets in the UK, have those dealt with in the UK. So I would suggest that if you have a UK will and you still have assets in the UK, that's fine. You should create a new will if you're resident here and have assets here. And then most wills typically start with the phrase, I hereby revoke all previous wills and testaments. You're going to have to let the lawyer know who helps you draft it, or however you prepare the will, that you have to create an exception in that phrase that says, I hereby revoke all previous wills and attorneys, all previous wills and testamentary documents previously executed, save and except for a will executed on such and such a date that deals with my assets held in the UK exclusively. And the same would be, so for example, if you continue to have Ontario assets, I would leave the Ontario will. So that lets me expand on this answer a little bit. I would probably leave the Ontario will in place and use the same phraseology in your BC will. So your BC will would say, save and except for. And this way, the unfortunate thing is, again, in this scenario, you want to do a little bit of planning because you don't want to have to apply for probate in BC and Ontario at the same time. And there's ways for that to be avoided, but it's a little, I think it's a little too complex for the purposes of this discussion. If you find yourself in that scenario, I'm happy to discuss that a little bit further with you. So question 3, this is where I think I combined a couple of questions because they related to the same subject matter. So if I were to pass away 3 years before my dad and my will has already been dispensed to my children and closed, how would my father then direct what would be my portion to my grandchildren? Would the inheritance allotted to me automatically go to my brother, if not stipulated to my children, and vice versa, if my brother should pass before my dad? Does my dad need to make provisions for this in the will? So, the answer to this is, firstly, everybody's will deals with their own estate specifically. So in a scenario where you predeceased someone who's left you as a beneficiary, the fact that your estate has been wrapped up doesn't really affect the fact that you're the beneficiary, other than or depending on how that will was drafted. So, there's two different ways that a testator can manage their bequests. One is to provide for, in the Latin terms, would be a per capita distribution, meaning he's leaving money to whoever the beneficiary is for that beneficiary exclusively. Or a per stirpes distribution, meaning if that person is predeceased, that distribution will go to members of that same bloodline. So basically, if a parent has a child that's predeceased leaving grandchildren, then that person's share of the estate would go to their children or the grandchildren. Now, there's various different ways to draft this. So one way is to simply say per stirpes, that deals specifically with bloodline. Today, things like blended families are much more common. separation, divorce are much more common. So you'll just see references to my children specifically, or the names of the children, or children being defined with the various names of the children. But all in all, it's up to the will of, or the instructions of the testator in their will. So absolutely, it's their decision as to whether it just stays amongst their children. So for example, if you had 3 children and you wanted all children to get a share equally, but that it wouldn't pass on to their own children, then yes, if one predeceased, what would have been 3 shares is now 2 shares. If there's 3 children and one is predeceased and you did make provision for your grandchildren, then it would still be 3 shares, but that 1 share would be divided equally amongst the children of that child that is predeceased. And I think this would be a good time to let people know as well that one's will and one's estate is one of the few times where you can actually exclude specifically the assets that someone inherits from any family law property. So a couple that are married, whatever one of the individuals receives as an inheritance does not become part of that family property. And a properly prepared will usually include provisions that specifically state that it won't form part of the couple's property, for those who worry that their children might end up divorced or separated. Now, the second question that I combine with this is that my husband and I completed our wills in 2004, each containing a bequest to our siblings, should both of us be deceased. Since then, one of the brothers has died, but his bequest specifically says that in the event of his death, his portion would be split among his issue. Basically, nothing else has changed. Do we need to redo our wills? Based on what I just explained about the first question, I'm sure you all realize that the answer to that is no, because the inheritance that goes to the brother who's predeceased, it has been stated in the will, should go to that person's children. Sorry. Next. Okay. What is the legal definition of a principal residence? How much time do you need to be at that location to claim it as principal residence? So for those purposes, I generally recommend that we use the CRA definition. And the CRA definition is that you've lived there for at least 1 year. And, you'll have to be able to prove it. The simplest way to prove it is to confirm that, for example, if you have a driver's license, you've changed your address on the driver's license to that address. That's proof positive. If your bills are coming to you at that address, again, proof positive. So, because, again, people who own 2 properties or people who own an investment property, if you as the landlord are paying the bills, usually the bills will be coming to your office or your own residence. So those types of things make it difficult to prove that the property that's receiving those, or the properties that concern those bills, are your principal residence. Okay. And I put these 2 questions together because they deal about real estate. When you create a will for yourself, how do you account for a property that has been bequeathed to you, but by intestate parents? Parents did not have a will, but still maintain title. So this is more complex than it appears. Let me simplify this scenario. Parents, let's say parents X have passed away owning a home, perhaps as joint tenants, and they had no will. And so typically what should have happened, and all should be aware, is that when the spouse of a couple, or basically when one party amongst joint tenants is a land registration, a form of land registration that provides for right of survivorship. So it means that whoever's registered on title, if they're all registered as joint tenants, it means that as people pass away, their interest in the property automatically passes to the other individuals registered on title. For the purpose of this conversation, we'll deal with it as if it was a married couple that owned the property as joint tenants. So once one parent dies, now this doesn't have to happen right away. Obviously, people need time to grieve and manage other more pressing matters, that have to be dealt with when one's lost a spouse or a longtime partner. But I would say that within a reasonable amount of time, let's say within the first 6 months, it's really important that that person take the steps to file and register what's called a survivorship application that transfers title solely into that surviving spouse's name. And the reason that it's important is because with the exception of the joint tenant provision, any other attempt at transfer, requires the signature of both parties. If one party has passed away, then that means that a certificate of appointment of a state trustee is required. So that's an application to the court. If the person has died with a will, then it's an application with a will. If they've died without a will, then it's an application without a will. But basically, the most logical person to be their trustee would have to file this application. And the process is time-consuming and expensive. And so the likelihood of this being necessary increases if both title holders pass away. So the longer that surviving spouse waits, the more likelihood that they might end up also passing away, leaving their children or other more remote relatives who are their legal beneficiaries under the Succession Act, or perhaps under a will, to be able to transfer title to either sell or even manage the payment of property taxes, insuring the house. All of these things get more complex. So it's important to remember to do this survivorship application within a reasonable amount of time after one of the joint title holders passing. In this case, we have both parents. This is the scenario I'm cautioning you about. We have two parents who've died intestate, but are still both on title to the house. Now, there's a few things that could help here. There are a few rules that apply to property that may save these people from going to property, having to apply for probate. One is called the first dealings rule. So it means if someone purchased their home prior to, in some cases prior to, 2006, 2007, but in most cases it's prior to 2000, and they purchased it. They purchased the home, and no registrations have occurred since. So the mortgage was paid off prior to the target they were looking for is in Ontario, much like everywhere else. Ownership of land was registered in books that were maintained in land registry offices. By around 2000 and between 2000 and 2006, all title to all these properties was converted from the book-based system to an electronic system. In the real estate law world, we call that LTCQing. If no registrations have gone against title, so nobody's registered a mortgage, nobody's registered a lien, or the house wasn't sold, or then you can rely on what's called the first dealings rule, which means they could transfer title of ownership to the natural beneficiaries under the Succession Law Act without having to get probate. But this would have to be very clear. It couldn't be if it's muddy at all. So if the people died having no children and now it's cousins or that kind of thing that are making the application, I as a lawyer would probably force them to get probate just so that people can't spring up out of the woodworks and say, well, wait, I should have been the appropriate beneficiary for these assets. The other exception is what's called the 3-year vesting rule. So, for example, in this scenario where the parents both died intestate, if the person whose name on title died 3 years, 3 years prior to the date that they're looking to transfer, then there's a rule that says that property vests automatically in the beneficiaries within 3 years. Again, it has to be very clear who the beneficiaries are. So, obviously the easiest scenario would be biological children that are all acting as a group. So, for example, if there's 4 children and one of them is claiming that perhaps they're entitled to more because they were primary caregiver for a bunch of years and that kind of thing, then you may want to get probate just for the purposes of avoiding any legal hiccups later on, and at least get that all sorted out prior to making the application. Okay. Next question. If someone that you have left money for in your will legally changed their names, do you have to redo your will to accommodate the change? No. Again, I say no, but I qualify my answer by saying that it also will depend on the level of complexity in your will. So if you've made sort of, if you've drafted your will and you've left money to your children and you have 2 boys and 2 daughters, and your daughters perhaps have married and taken their husband's name, then everyone will know, or at least the world is on notice, that if that person is your daughter, that's who you meant as the beneficiary. And so no, I wouldn't necessarily change the will. Again, husbands taking on a hyphenated name, which is happening more and more often. Again, same scenario. The jury's out. I'll be honest with you. The jury's out now that we live sort of with transgenderism becoming much more common, etc. I have had clients who wanted to change their wills because their former sons, now daughters, have changed their name, and or vice versa. Again, I'm not sure how necessary it is, but if you want to act with an abundance of caution, I would say that you may want to consider changing your will at that time, or maybe making a codicil under those circumstances. Again, this might also apply to blended families where adoption is involved. So, for example, you might have a predeceased child who was married and had children, and after their death, the spouse has remarried and adopted the child, and perhaps that child has ended up taking their name. So again, there are provisions in their will that account for the possibility of adoption and how adoption might affect their being a beneficiary to your estate. And it's something that people need to think about in terms of whether they think a child that is part of their bloodline but has since been adopted by somebody else should still be entitled, or if it's their own child that has adopted somebody else's child. So now your beneficiary is the adopted parent of someone that's not of your bloodline. Do they qualify as someone who should be a beneficiary if your child predeceases? Those are things that all have to be considered, and that's where name changing might come in. But I think that decision is part of the bigger question of how you want to deal with potential adoptive beneficiaries. Question 8. Can a man choose not to inherit from their spouse upon the spouse's death? I.e., is he bound to inherit just because the law says he is entitled to half of his estate? He may have his own income stream and not wish to receive more. There's a lot to unpack here. So let's start with this concept of entitlement. Unless the person dies intestate, and leaving, excuse me, folks, and leaving family law claims out of it for the moment. A spouse is not necessarily automatically entitled. You can, a testator can bequeath their assets to anybody they like. Doesn't necessarily have to be their spouse. In most cases, it is their spouse. I would certainly question and want to know why somebody didn't want to include their spouse. But it isn't necessarily a requirement, except in the instance where your spouse is a dependent individual. So your spouse is dependent on you for their support and care. And that's where family law issues come in. And so a spouse that's left out that is dependent on the testator has a legitimate claim that they should be treated as a divorced or separated spouse and should therefore be entitled to support from the estate. But now let's get to the bigger question. This clearly revolves around tax. And so as a broad, and I say this to my corporate clients, I say this to my wills and estates clients, and I should mention, as part of my background, the way I started practicing in wills and estates nearly 20 years ago was working in-house with a wealth management company and providing estate planning to high net worth individuals. So that's really my specialty in the area of wills and estates. And so I will say that efforts to avoid taxes, when taken too far, generally lead to very bad results. And I'll also say that when estate planning or even, when estate planning or business planning, avoiding taxes completely is virtually impossible, except for the super rich, and that leads to a whole other discussion. So the proper way to tax plan is to look at the degree of taxation and what the cheapest form of tax is. So I will tell you that as far as taxes go, probate taxes are the smallest tax you will pay on anything. Typically, it's 1.5%. I mean, on the first 50 or 150,000, it's oh no, now they've harmonized it, so it's 1.5 across the board. So at 1.5%, the second best tax would be capital gains, which is basically 25, well, it's 25% of, it's 50% of 50% of whatever the capital gain is. And we'll talk about another reason why one of the more common tax planning, estate planning models is now becoming more challenging. So, but this person says that, perhaps they don't want to inherit their husband's estate because of income. So the first thing is the estate is taxed at the estate level. The beneficiary is not taxed on it. In Canada, there are no estate taxes for the moment. So that beneficiary receiving the estate, they receive it on a tax-free basis. Okay. What they want to do, if it is an income generating asset, and they don't want the income, they can either sell it or they can proceed to gift it or gift, they can gift that asset to perhaps a child that is in a better tax class at the time, so it doesn't have as big an impact, right? But at the end of the day, I would not. So the answer is yes. Someone can say, I waive my entitlement to this bequest, but I wouldn't do it for the reason that this individual asks, right? I would absolutely accept it, and then with the assistance of a trusted advisor like Trudy, and perhaps their lawyer, I would look at better ways to plan how I receive my income to avoid paying excess tax. And, again, the truth is the only circumstance that I could envision in this scenario would be somebody who is at an income tax level where they're already paying at the top tax bracket 53%. So the increased income isn't going to increase their tax level. But if they'd like this money to go to somewhere else where it would be more tax efficient, again, that's something that they can probably manage with their own financial advisor, or perhaps that's how the will should be organized, right? And that's something that can be reviewed well in advance of having to deal with the assets. So again, in terms of estate planning, a lot of people look to taking certain steps to avoid having to probate certain things. And in some cases, I can understand. Now, with the average property value being, $1 million, you will pay 1.5% on $1 million. It's a lot of money. It's, $15,000. So it's not an insignificant sum of money. So you decide to add your children to title, or you add them to an investment account. So effective 2023 for the 2023 tax year, and for anybody on this call who isn't aware of this yet, I urge you to pay close attention and contact your accountants. The government has introduced a new income tax law that says that all trusts, the trustees of all trusts, must file a report. I can't remember the number of a form, but it's a new form for each trust that they're the trustee for. So if you've put one of your children on on title to the property of your home, that is considered a trust. So that child would have to file a report that states that. Now, for some reason, CRA isn't requiring information about what the asset is that's being held in trust. They just need information that the trust exists, who the trustee is, and who the beneficiary is. So for the moment anyway, this appears to be an information gathering exercise, but you can be assured that should it continue and remain in place, they will start inquiring about assets and start looking at taxation opportunities. But for now, the cost will be the cost of the filing. And from the accounts I've spoken to, they're charging anywhere from $750 to $1,500 per filing. So if you've gone on title to, or you've brought on your children on title to your home and your cottage, those are two separate filings that could cost you $1,500 to $3,000 a year for those filings. There are ways perhaps around it. Like anything else about taxes, everyone is always looking for avoidance mechanisms. I think we have developed one that I think we're not the only ones use or will be using or offering to our clients, but I'll talk about that in a minute. The same goes for investment accounts. And so these are things that I think need to go into consideration when you're looking at those types of tax planning ideas. Now, one of the things that we've recommended, or that we are recommending to our clients in that situation, is that when they put there's two ways to go about it. And the only way to do it is that it's either an absolute gift, or they've acquired title, by purchasing it for fair market value, or purchasing their entitlement for fair market value. The problem with an absolute gift, you could provide a gift letter, but then you run the risk of a high capital gain for those children, perhaps, or those trustees that already own their own real estate, own their own home. The capital gain could end up being substantial. So what we're advising our clients they can do, well, for those who are contemplating doing it now, they may want to consider just not doing it at all. Because the truth is, when you do it, you really don't know how long they're going to be trustees for. So if they end up being trustees for the next 10 or 15 years, you can do the math. It's going to cost you perhaps $15,000 in accounting fees. Might be the equivalent of what you're paying in probate. So why bother? But anyway, one of the workarounds is that basically acknowledgement that the child has purchased that interest, be it a half interest, a third interest, at fair market value on the basis of a promissory note. A promissory note that by bequest in the individual's will is forgiven upon their death. So no money changes hand, no capital gain is accrued because they bought it at fair market value, or at least any capital gain that accrues to your trustee or your child or beneficiary that you put on title is set at any increase in value from the fair market value at the time that you added them to title. So, and then because there was a question here, someone asked a question about setting up trusts and
Yeah, I
moving
think question
assets into
7.
trusts.
Yeah, question
Yeah.
7.
Was that question 7?
Yeah, I think
Oh,
you
there we go. I guess I skipped it. So my wife and I would like to set up a trust fund to incorporate our wheelhouse savings investments, hoping to avoid probate. So unfortunately, so a trust is good uh, if there's several minor children. If you want to build wealth for a long time, my advice to people is if your estate is in excess of, say, $10 million, perhaps five, but I would say closer to 10, then you may want to consider a trust. Uh, and the thing about a trust is it's something that should be formed early in your estate planning process, because to do it later will likely result in increased taxes than that which you would have paid in probate. And I'll tell you why. Firstly, first of all, there's the new trust accounting rules. Secondly, about 10 years ago, the government said that unless the trust distributes all its money every year, the trust is taxed as an individual at the highest marginal tax rate, regardless of what the earnings are. So that means you're not accumulating wealth anymore, or if you are, you're paying the highest marginal tax rate on it. And so that doesn't provide for good estate planning. So my answer is if you're at the very, and then the other part is if you already own all your assets and you're planning on moving them into a trust afterwards, you're deemed as having disposed of it at the time that you moved into the trust. So now you're going to pay capital gains on anything that attracts capital gains. So you're creating a tax nightmare for yourself if you already have significant assets and then try and move it into a trust. And so I know that a lot of people are promoting things like alter ego trusts and the kind of trust that you establish for your own benefit. But in the long run, it just unless you're willing to make the large tax payment that comes with doing it, it's so if it's something you're planning, you need to do it in association with all your financial all the professionals that assist you in managing your finances, from your financial planner, your accountant, and your lawyer, to make sure that it makes sense for you. And that's not even including the cost of setting up the trust, which, and again, depending on the type of money we're talking about, may or may not be all that significant. But I urge caution if the plan is to move things into a trust. But there are different benefits. So setting things up in a trust certainly creditor proofs those assets. So if you end up being sued and successfully sued, the litigant can't necessarily pursue assets that are in trust for family members as the beneficiaries, creditors as well. So for that reason, they may be beneficial. Something I wanted to add also about this other question about the spouses leaving their assets to each other. one also has to consider registered accounts. Again, depending on your age, it may not matter. So, for those above the age of 75 or 80, and you're already at the RIF stage where you're deducting 10%, it may not matter. But prior to that, again, you always want to name your spouse as a beneficiary because it's your only opportunity to defer taxes on funds that are held in registered accounts. You can only, if you've left a child as a beneficiary on a registered account, then as soon as you pass away, uh, everything in that registered account is taxed in full prior to being paid to that beneficiary. So, you really want to be careful about, you want to take advantage of every opportunity that's given in terms of spousal beneficiaries. Now, before I take any questions, I want to make sure that you all understand this presentation. There's a cautionary note involved. The answers I'm giving are very general without any specific knowledge of anyone's circumstances. So the commentary is a summary in nature and doesn't address all the issues and considerations that may be relevant to your set of circumstances, and it doesn't represent legal or tax advice. So I'm happy to speak with any one of you individually, more specifically, but as far as this presentation goes, please be aware and acknowledge and realize that please don't sue me over anything you may have heard or read in this presentation. So let me see what's going on in the chat room because I see there's 15 messages there, and see if there's any questions I can answer there.
Leon, one of the questions had said, what is probate?
Yes, I
So
think
if
I
you,
see that you answered that.
yeah, but I mean, you can just trying to help you out here,
Sure. Lived in our house for 47 years. What documents should we have to prove ownership? I like that question, Maddie. So firstly, that's an easy one. You can, well, first of all, your tax bill. So your tax bill generally will reflect who the owners are. And if the names on the tax bill are incorrect, you might have a title issue. And then I would call my office or a lawyer that you work with and ask them to obtain what's called a parcel register. Now that everything's electronic, that's very easy to do. The cost is about $38 in service fees. And then you can find out exactly what's there. Now, Patricia, perhaps you can jump in here. Oh, yeah, there's someone we may have missed Q7. I'm glad I went back. What is the bare requirement? I'm not sure what that question means. So, Patricia, if you want to unmute yourself, perhaps, and explain, I'd be happy to answer. And until you come along, Patricia, I will continue. Oh, this is the bare trust. Okay. So a bare trust is, again, a bare trust is a trust that is observable to all. Basically, everyone is on notice that the asset is being held in trust for some other beneficiary. So you would have a simple trust declaration document or some sort of simple agreement between the trustee and the beneficial owner that says that the trustee is the legal owner in trust for, or bare trustee for, the beneficial owner. So in real estate, again, that would be putting your child on as half owner of the property that you own. That child then becomes a bare trustee. So, opinions vary. The next question, is it a good idea to have your children as trustees? In our case, there will also be the recipients of the estate. So are those that say that it isn't a good idea. I am not one of those proponents. I think, but there's a caveat to that. A lot of it depends on your family. So if you have 4 children and everybody gets along and everybody is functioning as productive members of society, and you have a family that, there are varying definitions of close, but if your family is close. And I think you have a sense of whether your children will, become antagonistic amongst themselves once the division of the estate comes along, in which case you might not want to have them. And again, I think a lot of it depends on the size of your estate, because again, if you leave someone else as the trustee and your children are just starting out in life, or even perhaps some of the funds are held in trust for grandchildren because you have a child that's predeceased, that means that they have to go to the trustee every time they want money. So you're kind of, number one, it's a big job for the person who is your trustee. And if the estate isn't sizable enough to perhaps allow compensation for that trustee, then I think perhaps it's not a good idea. Again, if circumstances allow. So I guess the simple answer is, if circumstances allow, I think it's always best to have the children jointly, as your trustees. It's just the simplest route. Other considerations, now because we live in much more global environment, I meet a lot of people who have, 3 or 4 kids. One of them might live locally in Ontario, another might live in BC, another might live in the States or the UK or wherever. In Ontario, if you have an out of jurisdiction trustee, is typically required to post a bond to guarantee, primarily is to guarantee the probate taxes will get paid, but it's also to sort of protect the beneficiaries. Now, again, this can be avoided by making an application to waive the necessity of a bond, and typically the court is agreeable to that sort of application, but it just adds to the complexity of the application, and on occasion they won't agree. So, if you have 4 children and only one of them remains in Ontario, again, your consideration should be given to perhaps just that child being the trustee. Yeah, and again, paying attention to all of the circumstances. Will this cause a fight amongst the children? Will the other children be like, we don't trust that particular sibling of ours, and et cetera, which, it's funny, but to bring this all full circle back to my very first question, you can see that even the simplest questions can get bogged down in complexities when it comes to your estate planning. And so, but they don't have to be complex. Most of them are dealt with if your lawyer has sufficient experience and knowledge of will drafting and estate planning. A simple conversation can likely help find the properly drafted provision that you want to deal with your scenario. And I specifically say this in the context of all these computer-driven, AI-driven will and estate planning websites, because there's really no one there to talk to. There's nobody there to sort of tease out some of the information that really is, as you can tell, it might seem trivial or unimportant at first blush, but as you discuss it, you can see how important it is or can be. Oh, there we go. The T3 trust income tax and information return question. Actually, no, I think this is a different type of return. I don't have time to look it up now, but I'll send that information to Jen. I believe it's a different, the document has a different number to it, but this would be the normal return for an established trust. And by trust, this is more like a unit trust, an alter ego trust. This is the form that people have to file now. Literally, is just information about who the trustee and who the beneficiary is. These returns include information about assets and income. You won't have to do that in the new ones. I'll get that information for you. What is probate? So yes, so the idea is probate is the is the acronym that they used, or the term of art that they use to describe what's called an application for appointment as a trustee, either with or without a will. And basically, it's an application to the court. If you have a will, you provide the original copy of the will, the names and addresses of all the beneficiaries. You need to include if there are children out of wedlock, if the person was previously married, if they're unmarried at the time of their death. Information about any beneficiaries that are minors or disabled. And then the court looks at everything in its totality. And if they feel that everything is fine, then they'll issue the certificate. If there are questions, like, who represents the minor child, are the interests of the minor child being protected, or, for example, the disabled dependent being protected, then they will either ask for further questions or ask for various applications. It's also an opportunity for those that may want to challenge the will, which is happening more and more frequently, unfortunately, for reasons primarily of demographics and the fact that there's now a lot of money at stake. But if someone wants to challenge a will, that's usually the time, because everyone who is a beneficiary is provided with notice of the application. And for a certificate of appointment without a will, it's generally a must if the person had investment accounts. Investment accounts are generally the only ones where there's literally very few other alternatives to avoid it. For two reasons. One, the banks don't want to make mistakes. And the second is that they don't want to let go of your money. So the probate process allows them to hold on to it that much longer. Okay, let's see what else. What deemed disposition assets require proof of capital gains? So, well, I mean, basically, any investments, real estate, anything that would attract capital gains, if you're moving it from your personal holdings into a trust, then yeah, it's between you and your accountant. You have to establish what the capital gain is, and hopefully CRA agrees. And if they don't, then you're going to have to prove to them why your number is the right number. And again, I guess it's the same thing when someone passes away, because much like transferring funds to a trust, when you pass away, with the exception of those things that pass to a spouse by rights of survivorship, everything else is deemed, in all other circumstances, you're deemed of having disposed of it. That's why taxes on your registered accounts are automatically payable unless they transfer to a spouse. Investment properties, same thing. Which is why, and again, you have Trudy here as your financial planner. One of the other professionals that can be very helpful and should definitely be on the list of people you speak to when you're doing your estate planning is an insurance agent, because insurance can be very helpful in helping you make sure that there's either cash available to pay for, if there isn't already cash in the estate. Or it can equalize. If, for example, there's a family asset like a cottage, and really there's only one child interested in it, or you're planning on leaving it to one child, or you're planning on leaving it to both children, but giving one the opportunity to buy the other one out, that might not be possible without a mortgage. But insurance, again, can help mitigate that issue. One other thing I want to mention that wasn't in here, for those of you that own shares of private corporations, so if you do business through a corporation that you own, and especially if you have retained earnings in that corporation. So for tax reasons, you haven't drawn money from your corporation. You've always taken a salary and left any excess in the corporation as retained earnings for the possibility of withdrawing it when your income declines. You want to make sure you have a proper will structure, which will generally mean what's called a dual will structure. Some call it a public-private will structure. Basically, this is another exception to your typical CRA rules. CRA rules say that shares of a private corporation can be, and also estate rules say that shares of a private corporation and certain other assets, like a home or property that hasn't been LTCQ'd before, remember this goes back to the first dealing rule we discussed, they can all be passed on through your private estate, your private will, which does not require probating. So this is one of the good ways to avoid probate. If you have assets that can pass, that qualify as private assets. So again, shares of a private corporation, real estate that hasn't been LTCQ'd previously, certain other items of personal effect, like artwork. I haven't met too many people with artwork that is a significant asset, but of course it's out there. And so this is where a dual will structure should be considered. Okay. I'm a single woman with few assets, primarily life insurance. If I have no relative or friend who is willing to be an executor and make sure that my remains are buried legally in the, what is that? There's something blocking, but it's legally in the environment about 100 miles away from my town. Is there a professional whom I could contact to ensure my wishes are done? Wow. Executor is going to be from a friend. Yeah, you know what? I would find a lawyer who's willing to be your executor. So, and it doesn't sound like it would be too challenging in this instance because there's no real disbursements involved and it's just life insurance. I guess the most significant question is, other than your funeral expenses, you're probably going to want to name some sort of charity as the beneficiary of whatever else the proceeds are, because it doesn't sound like your funeral expenses are going to be that costly, to be honest. So it would depend on those costs and what the value of the insurance policy is. But in this instance, I would definitely look for a lawyer who's willing to act as your trustee as well. Oh, there's Maddie. Okay, let's see what else. Is it advisable to be your children? So yes, I've already dealt with that one. So and the answer is, in my opinion, yes. Low expenses and charitable donations with whatever is less. Yeah, I think that's probably in response to the question about the insurance policy. And so for now, I don't know how much time we have left. I'm free for another 15 or 20 minutes. So if you want to open the floor, Jen, or give me any questions that other people may have, I'll be happy to answer.
Awesome. Yeah, you guys can put it in the chat or you can wave madly in your Zoom window and we can see if anybody's got any questions. Feel free to unmute if you have one. Just looking through here.
So Jen, Leon, thank you. I have to leave. I have another appointment.
Bye, Trudy.
But I will say to the attendees on this call, I have been using both personally and referring my clients to Leon. He is, I kid you not, the cream of the crop. Like honestly, he's so personable, honest, and transparent, and he's a hard worker. But he just likes dealing with people and giving the right, like good people the right advice. So if there's any doubt, please reach out to him. His office and his team, they're an extension of him. I'm Leon, you're my fave. So have a great night. And thanks, guys. Bye.
Thanks, Trudy.
So I see a question here from Richard. What happens to TFSA funds? So TFSA funds are registered accounts. You should be able to name a beneficiary to this one. And in terms of taxes, they get somewhat of a different tax treatment to so sorry. So
no, I think somebody just unmuted. Go ahead.
So in the TFSA, everything accumulates tax free. RSPs and RIFs, they don't say that it accumulates tax free. It's just taxes deferred, right? So when it comes to the TFSA, it'll pass to your beneficiaries free of tax, okay? But RSPs and RIFs are a different story. They're deemed of disposed of as they pass to your children, and they will be taxed. Is it a good idea to give some of our inheritance to our children before we die? Absolutely. If you're looking to save money on probate and you have the resources so that you know you're not going to need the money later on, absolutely gifting is a great idea. Of course, like everything else, it has to be done properly. So if you're gifting to one child at the expense of perhaps all your other children, or you're not doing equally, then you could be setting the stage for some serious legal disputes down the road. And I would, and again, if you are gifting, I would document. So, just a letter that explains that the money was a gift and that you completely understood the nature of the gift and its consequences. So again, later on, somebody can't claim that perhaps you didn't have capacity to make that gift or undue pressure was placed upon you to make the gift. Talking per stirpes. If you leave money to a child who dies before I do, and their child is a minor, what happens? So typically, a properly drafted will say that there will be provisions that any funds that pass to, or anybody who becomes eligible as a beneficiary prior to reaching the age of majority, or whatever age you choose. So it could be anywhere from 18 to 21 to the most common ages are anywhere between 18 and 25. Then that money is held in trust for the benefit of that beneficiary, and the trustee is authorized to advance funds to the guardian of that beneficiary for their upkeep. So schooling, clothing, basically their day-to-day expenses until they reach that age, at which point they're entitled to receive their full inheritance or whatever's left of it. Can stocks have a beneficiary named, or can this only be done through a will? It can only be done through a will. But I mean, these days, most people, if you have a brokerage account, or even if you're doing it on your own through Questrade or Wealthsimple or one of those companies, what you might want to do is open up a joint account between you and your spouse, and they will allow those joint accounts to have a right of survivorship so that it passes directly to whoever your joint account holder is. Will our kids be taxed since we're still alive? I'm not sure I understand the
That
nature
was
of
a follow-up to the gifting the kids money.
No, so that's why a gift letter is important. I believe gifting is tax-free if it's a legitimate gift. Is there a minimum amount allowed to be gifted per year per total? Not that I'm aware of. And again, this should be something that's done in in uh, in cooperation with your accountant. Make sure you speak to your accountant to make sure that you're doing it in a way that won't result in any taxation. Can we leave only to our adult children, but not to their spouses? Absolutely. That is not a bad question. And in fact, Maddie, a lot of people worry about, the spouses of their children getting their hands on their money. So as I explained earlier, spouses are never named in the will unless you want them to be named. So typically, you either leave it to your children generally, which means your biological children, or if you wish, your biological children and adopted children, and then if they predecease you, and then to their children. So completely skips the spouse. And if after someone has received the bequest, again, a properly word drafted will prevent that spouse from claiming any entitlement to anything received as part of an inheritance. Years ago, there was a law that you could gift up to 10,000 children prior to death per year, which is not part of the state. Is there any top amount now to gift yearly to children? Not that I'm aware of, but let me, I can have a look and get back to Jen on that. So we seem to have run out of questions. If you give me a second, though, I will find out about that question. How do I? Okay. Oh, there we go. Let me stop share. Great. So now you can all see me again. Okay. Sorry, I'm just going to uh, my estates resource platform. Yep, no, there's none. There's none.
So
So,
gift away.
so any gift given to your kids is done on a tax-free basis. Again, I would document it. It can be very, very simple. You know, on this day, I gave to my child X amount of dollars as a gift. There's no requirement for them to repay me these funds. It's for their own use, absolutely. Signed, such and such, and you're done. Uh, oh, can you repeat info on retained earnings in a private corporation? Yes. So this is an important one. So a lot of people if they owned a corporation after they've either retired or sold the business, they keep the corporation because, let's say they paid them a salary sufficient enough for them to live on annually, and the corporation made more money than that. The most tax efficient thing to do would be to leave it in the corporation. Because again, in terms of the thresholds or levels of taxation, the corporate tax rate is the best tax rate of all, especially in Ontario, where you're paying approximately 11.5%. And then everything else you leave in there is untaxed until you take it out. So what a lot of people do in terms of their tax planning is they say, we'll leave the money in the corporation. Once I'm retired, my income will go down because I'm no longer receiving the salary. Now I will start dividending myself some money. Your dividends are the second best level of taxation below, well, I guess the third after your corporate taxation, because remember, the corporate taxes have already been paid. Capital gains are the best. Then comes dividends, which are also based somewhat on your income at the time the dividend is earned. If you have no employment income, that dividend is cheaper, so people take the money out as dividends. Unfortunately, there are gambles in life. One of the gambles is that you may pass away before you've withdrawn all those retained earnings. If your spouse isn't a shareholder of that corporation, and already on as perhaps a director or an officer, then it's important that you have what's called a dual will. And that dual will means you'll have a private will that deals with those assets specifically, the private shares of that corporation, so that those assets don't have to be probated. Everything can just continue as it is, but your beneficiaries are now the official owners of those shares, and now they can start dividending out to themselves. So they can take advantage of the same tax breaks that you did prior to your death. And if anyone wants more information about dual wills, again, you can just contact me. Okay, where can we get more information on the Bear Trust? So I'm not sure. Again, so Larry, perhaps if you want, you can email me something, whatever else you'd like to know about Bear Trustees more specifically, and I'll see if I can't answer it for you. Which speaks of.
I think so, Leon, there was a question on, can RIF money be gifted to children and will it be taxed?
Yeah, so yes, the answer is yes, and there's no limits.
Okay,
There's
great.
no limits.
Oh, there's no limits to that. Okay, great. Sorry. And then Karen said, if you did everything to ensure that only your child and not their spouse receives their inheritance, your inheritance, but they bought it
Okay.
together,
Yes.
will they get half of it in the
So
adult?
the answer is yes. When they get the money, it doesn't form part of community property. But if they invest the money, that investment becomes part of the community property. But a house is somewhat different. So they can enter into an agreement with each other that says that the person who used their inheritance money to buy the house, is the individual that contributed that money to the purchase of the home. And should something happen to them, whether it's divorce or sale of the home, that individual who contributed that amount receives that money back from prior to the division of all other assets, and that would also hold up in the event of a divorce or a separation.
Okay, great. Did you see this one? Can a clause be included in an Ontario will?
The answer is yes, but it's not necessarily enforceable. So we deal a lot with this in terms of people who own real estate in the Caribbean, for example, most often, and places where the land title system is different, the state administration system is different. It's complicated. So the clause that needs to be added in Ontario or in your Ontario will is the clause I mentioned earlier, which simply says that I hereby revoke all of the wills and testamentary provisions previously made, save and except for my will dated whatever, dealing with my assets located in the UK or whatever foreign country it is. And then I would make sure that you have some sort of testamentary documents in that country. In all likelihood, a will. So we deal with people online. We do video conferences. We can take instructions over the phone. The way we typically do things is you contact our office. We send you out a wills and estates questionnaire that basically gathers the information we need to draft your will. We also send you a couple of documents that sort of explain the more common provisions you'll find in a will. So the more common clauses and some of the stuff we've talked about today, and also some information about proper storage of your wills. And then we either, draft and send it to for your review, and we meet either over the phone or via video, and we can even do electronic virtual signings as well. So yes, the only thing you can't do is make the appointment online. We're working on that, but right now that would be a nightmare because we're so busy. So I have an assistant who works exclusively in the area of Wilson Estates, and basically, once you've contacted us, everything else would be arranged through her.
As you can see, that Leon's information is all in the chat. It's
Yeah.
also
Oh, and you know what? Let me give you all my personal email address
okay.
and my assistant's email address. And what is this?
And if for some reason you lose that, you can just send me an email and I'll send you all the contact info.
Yes. Well, and I think if you distribute that slideshow presentation I sent you in PDF, it'll have all our
Okay.
contact information as well.
Yeah, so not today's presentation, but it has why you need a will is what Leon is talking about. That was in the email this morning as well. So if you want to download that, you will see all of Leon's information on that as well. And if you missed that, send me an email and I can send it back to you as well.
There you go. And I've just given you all my and Melissa's email addresses.
Awesome.
Yeah.
Well, thank you so much, Leon. That was so much information. That was
Well,
great.
and thank you, everybody. This was a pleasure to see you all, and I look forward to speaking to many of you.
Absolutely. Thanks a lot, Leon. Well, I hope you'll come back soon because it sounds like this is a very interesting topic that people want to know more.
Anytime, Jen, you just send me the dates, I'll be there.
Okay. Thanks a lot, Leon.
Thanks,
Everybody.
everyone. Have a good
See you
rest of
later.
the day.
Bye-bye.